Hi, hello friends. In the legal history of India, yesterday would be marked as an unfortunate day when both the executive and judiciary collaborated in committing open and brazen contempt of the legislature. Rather, I would say of supreme legislature. During the hearing of Waqf matter yesterday, the central government gave an undertaking to the Supreme Court that till next day of hearing it would keep certain provisions of the Waqf Amendment Act of 2025 on tenterhooks and would not give effect to them. Now, this was an undertaking which could not have been given and which could not have been taken under. On its part, the Supreme Court, looking at it as an escape route and opportunity to avoid dealing with prayers for stay against the new law, not only permitted such undertaking to be given by the government, but happily took it on record. After passing of the Waqf Amendment Act 2025 from both houses of the parliament and its subsequent promulgation through notification after presidential assent, the legislation has come into force. It contains necessary mandate as a law passed by the parliament for implementation and legal force that is binding upon the government, the executive. Under no circumstance, the government has authority to stop implementation of the law by itself or by any other agency. Any deliberate endeavor to thwart the implementation of the law passed by parliament amounts to mindful abrogation of the law passed by supreme legislature and is thus its clear contempt of parliament. A law passed by parliament can only be stayed by the constitutional courts for its being violative of fundamental rights guaranteed under chapter 3 of the constitution, or can be declared void and struck down on this ground alone. Courts can interpret the intent of legislature behind the law, but in any case cannot go against it. As Supreme Court shirked its duty in protecting Chapter 3 against the apparently malicious and communally charged offensive law on Waqf amendment, it timidly sought shelter under the undertaking given by the government. In its anxiety to escape the rigors of the courtroom debate on stay of the disputed law, the Supreme Court not only permitted the central government to make an illegal undertaking before it, but itself directed it to be taken on judicial record. And it is shocking. The undertaking says that till next hearing, the government would not denotify any property registered or notified as Waqf property and would not make any appointments on the boards of Waqf board or the Waqf councils, giving effect to related provisions in the amended law. Under the scheme of the constitution, the government has no authority to make such undertaking. Any endeavor to block the implementation of the law passed by the parliament or any legislature for that matter is pernicious in nature and instantly illegal. It is punishable by the legislature itself for breach of its privileges. Passing the law, that is privilege of the legislature, and its implementation is mandatory. That mandate is entailed with every passing of the law by legislature. In making and recording such undertaking, Both the government and the Supreme Court have committed a blunder that would go down in legal history as no less than a crime against the Parliament and the Constitution itself. The hopes in legal quarters were really high yesterday, as many expected that Supreme Court would take a break from a long era of trailing behind the executive and would stay the law, or at least some of the provisions that are brazenly offensive and apparently illegal. But Supreme Court has disillusioned everyone. Chief Justice Sanjeev Khanna, retiring on 13th of next month, does not want to confront the central government with a stay order. Flanked by Justice Sanjay Kumar on the right and Justice Vishwanathan on the left, CJI Khanna probably would look upon a stay order against the new law as an avoidable misadventure at the threshold of his retirement. Friends, in trying times of fascism, judiciary is completely subjected to itself by the executive. While the executive misses no opportunity to attack and subdue the judiciary avoids being at odds with the executive. Even when the fundamentals of constitution are at stake, its foundations are being threatened. From Ayodhya to Article 370 and beyond, Supreme Court has a long history of being compliant to the executive. Having abdicated its vital constitutional role as watchdog of fundamental rights of citizens against the excesses of executive and legislature long back in history, the Supreme Court has taken to new role of harmonizing the law with these excesses and tailoring it to the needs of successive governments. Part of saffron political agenda of fascist Sangha Parivar, the amendments in Waqf Act are open travesty of the law and mockery of the Constitution, diluting minority character of Waqf alongside its assets that unofficially are estimated at no less than 2 lakh crores, is the core purpose behind the deceitful maneuver couched as amending act. Even core provisions of new law have scant nexus to the avowed objective of freeing Waqf from corruption. The corruption, on the contrary, and precisely, is rooted not so much in the working of Waqf as much in the maneuvers of the government in its malicious attempts to rope in the judiciary and the legislature, both in its designs to manipulate and defeat the constitutional guarantees to citizens in general and minorities in special. This was another occasion for the Supreme Court to prove its mettle, which it has missed where it seems to be failing again. In holding itself back from passing a restraint order against the illegal law, the Supreme Court is simply refusing to take a break from its dubious past. So thank you very much, friends, for being with us, and we will continue to bring such sort of exposures for you. We appeal to you to circulate this video as much as possible and subscribe both of our channels on YouTube and Facebook. Thank you very much. Thanks a lot.